Both reviews registered on the same day?
Yes. 13th December 22.
Right.
So much before registration, it had been sold off.
I got the point. We'll have to deal with this.
Yes, then 27th of January 23, the matter was, when tentative list had come out, it was to be listed in January. Then on 27th January 23, they circulated a letter saying that the listing may be held back for 6 weeks to enable filing of documents.
Right.
And then, my lords, the matter was listed, was supposed to be listed in 1st of February 23, not taken up 9th February, not taken up 18th February.
1st of March.
That's okay. Then what happened?
Finally, a notice has been issued on, matter came to be listed and notice was issued on 26th of September 24.
When was that period?
Right.
So submission is that this delay was being caused deliberately, this application documents to be filed because one of the learned judges who had delivered the judgment was about to retire. So when he retires, then the matter comes up and is taken up. Your lordships have in Vedanta taken the view that this procedure adopted by review petitioners is not acceptable. So these are the two things, and therefore, now in between, since the limitation prescribed is of 30 days, the purpose is that the winning party will act on the judgment.
Give a point, we'll hear the other side on
Yes.
that.
Beloved, only one more feature. Beloved, I mean the other connected matter, only one more feature. Beloved, when the matter was about to be listed, beloved, they wrote a letter to the registry telling the registry to hold back and not list the matter.
That Mr. Dwivedi also told us that
Yes,
because they wanted
beloved,
to file some
I mean, if you are
documents.
playing ducks and drakes, and today, beloved, notice is
Mr.
issued
Dwivedi
in.
has the same point, no? Yes, Mr.
Yes, the same point.
Dwivedi has made the point.
Yes.
May I-
We'll have to deal with it. You
I
can
will.
give us some broad facts and then deal with this
Yes,
point.
yes,
because
my
it
lords,
will-
also because otherwise under the Transfer of Property Act, the rule of lis pendens applies from the day the petition is instituted. So to say that it was registered a month later or a month and a half later makes no difference. You waited till the day I filed the review petition, and within a month thereafter you sold the property. So you admit that the review petition was filed. The review petition is filed on the 23rd of September 2022, and second date you gave was 27th of September 2022. A month after that you sold.
They get notice of the fact that review has been filed.
No,
Yes. So copy is served.
no. When did you serve?
Just, Mr. Call, just don't answer offhand. Ask for
I will,
record
I will.
and then deal with it.
Manoj, let me just
Yeah.
at least begin with the
All right.
facts and show to
But
your
this
lordship.
is still in our mind because we'll
Yeah.
have to deal with this issue because
Yes.
if they are right, then we have to dismiss your review straight away.
Yes,
So you can just, when you are arguing, you can ask somebody else to verify these facts.
yes. Now, my lords, kindly have 2 or 3 paragraphs which I had respectfully submitted, that where is the error apparent on the face as far as facts are concerned. As far as between us and the respondents, we are now the petitioners in the review petition. We were the respondents. Clearly, the agreement in question is an agreement dated 26th of March 1997. And 27th of March 1997 for the second pass. Because what had happened was, my lords, that respondent 1 to 4 sold the property to respondent 5 to 10 by way of 2 agreements for a contiguous piece of land with respect to about 127 acres. This was inter se apportioned between 5 to 7 and 6 to 10.
So R1 to 4 sold to R5 to 10.
Yes.
And what are those dates of those agreements?
The dates are, the date they sold was 19th of March 1994.
Right. And these two agreements which you said of 26th March 97 and 27th March 1997,
Yes.
those are between whom? Obviously with you as one
Yes,
party, but
yes.
who is your vendor?
Our vendors are 5 to 10.
Oh. So how do we describe you?
As the purchaser,
As the review petitioner.
review petitioner and the purchaser of the property, my lords, because really the transaction is between me and 5 to 10 who asked for specific performance.
Right. So your agreement with respond numbers 5 to 10 is of 97.
Yes.
Our 5 to 10 acquired the property in 94, 19 March 94.
Yes.
Right.
Now the fundamental error which happens in the matter is this, or a mistaken fact is twofold. Because ultimately, what is to be seen was the suit barred by limitation or not?
That from the
High Court ruled in our favor, dealing with it, saying that, look, clearly time was not the essence. If forfeiture of advance money within 3 months was the ground, you should have taken action then. And in any case, 90% of the consideration was paid within the time provided. Since within those 3 months, they also had to produce the documents, which they did not produce. Thus, things went on, and finally we gave a legal notice, and at the stage of legal notice, for the first time, they refused performance. So the court said that taking Article 54 of the Limitation Act, if no time is fixed, the second part is where refusal to performance of the contract is given, limitation starts running from that date. That was a reasoned order. Neither did they ever forfeit, nor did they ever say that we are returning your advance. Nothing done, no correspondence on that at all was ever done. And clearly 90% was paid on time within the 3 months. Advance was also paid. And the High Court clearly came to a conclusion, although you say all documents are available at the stage of agreement to sell, but you yourself deny they were available. They were clearly not available. And if they were available, then where was the need to put that clause in the agreement to sell of the same deal?
agreement with them fixed 3 months time for completing?
For both things. 3 months for payment of the balance consideration and 3 months for giving the documents. And our respectful submission is that we paid 90%. And the only reason this 10% was not paid was because you were not forthcoming with your documents. And we kept approaching you, and ultimately when we sent the legal notice to you, you refused to perform the contract, and within 3 years of that, within 2 years of that, we filed a suit.
What's the date of the legal notice?
Yes. The legal notice.
Because Article 54 of the Limitation Act says 3 years from the date fixed for performance or notice of refusal.
Or notice of refusal. So the legal notice was given on 8th of February 2000.
And when was the refusal?
Refusal was on 14/4/2000. And the suit was filed on 9th of August 2002. Otherwise, I lose my. Can you explain these? And we filed. Now,
what is the fundamental error?
Yes, so that
we are in review. We are not in appeal.
Absolutely. That is why, my lords, the fundamental error which happens is that apart from not dealing with the contentions why the High Court is wrong and what the High Court says, the order under review says confuses with the original agreement between respondent 1 to 4 and 5 to 10
of 1994.
of 1994, and says since that agreement did not materialize, a last opportunity was given to you by virtue of the agreement dated 97, and thus clearly time was the essence.
But you are not a party to the 94.
It has nothing to do with me. Then it relies on.
Are you claiming rights under the 94 agreement as an assignee?
No.
It's a fresh agreement.
It's a fresh agreement.
Because 19 March 94 is the agreement by virtue of which our 5 to 10 acquired title.
That's right. That's
And based on that title, you enter into the agreement of
they
97.
became the absolute owners. My rights are not traced.
The agreement of 1994 is an agreement to sell.
Is an agreement to, is it a sale or an agreement to sell?
Agreement to sell,
Agreement to sell,
accompanied by a power of attorney.
accompanied by a power of attorney.
General power of attorney to.
But be that as it may, my lords, my case is that I have an agreement to sell of 1997 with 5 to 10, which they refuse to perform, despite 90% of the sale consideration having been paid within the.
You're not seeking specific performance of the 94 agreement.
At all. Not at all. Those respondents are made signatories to this agreement only for purposes of completeness. But our agreement is only for this, the 97 agreement. It is no one's case also that I'm seeking specific performance of the 94 agreement. That is no one's case.
And our 1 to 4 and 5 to 10 are parties to your agreement also.
Yes. Manoj, which very often is done for the sake of completeness.
So it's not just that our 5 to 10 are parties to the 97 agreement.
Yes.
You get our 1 to 4 and 5 to 10.
As a matter of abundant caution, as happens and very often in these agreements.
Now, what is the fundamental error?
Yeah. So the two fundamental errors which occur.
Just formulate them so that then we can call
Yes.
upon the others.
Manoj, because then I need to show those paragraphs.
Yes.
Because that'll be important. I need to show those
So
paragraphs.
just formulate the two errors.
Yes, yes. The first is the court says that you entered into the 94 agreement. Confuses, thinks I'm party to the 94 agreement. And because the 94 agreement did not materialize, the 97 agreement was an agreement by being a last opportunity. And thus time is the essence. Then it relies on clause 21 of the 97 agreement. To say, and I must tell you, Lordship, what clause 21 of the 97 agreement is. Clause 27 said that respondent 1 to 4, who have already received their consideration from 5 to 10 for the 94 agreement, will have no claim to any other consideration now being paid. So it has nothing to do with time at all.
What was the sale consideration fixed in the 1994 agreement?
In the 94 agreement. What was it in 94 agreement?
It was a larger.
No, what,
And whether that entire amount was paid by the vendor to the vendee?
Manoj, they don't have any dispute on that. They have no
So
dispute.
without execution of the sale deed, the entire sale consideration was
Yes,
paid.
and that was a much larger piece of land. That was 129 acres.
Therefore, they are the signatories to the 1997 agreement
Yes, but
as confirming party.
yes, but they have inter se never had a problem with respect to their sale consideration being paid to 1 to 4. 1 to 4 have never come and said that we've not been paid our sale consideration. Yes. Sorry.
What is this?
Second, what is the second error?
Second was that you gave a legal notice where you said and narrated a story, you meaning me. I narrated a story in that legal notice to say that you were not performing and you sought other buyers, and since other buyers were not coming forward, you came back to us to complete the transaction and approached us again. Now, firstly, how does that make time the essence of the contract? Either ways, nothing turns on it. It doesn't make time the essence of the contract because that's the whole issue. Now, let me just show to your lordships 3 or 4 paragraphs of the order under review and the 3 paragraphs they are relying on. Let me just show that to your lordships.
Yes.
And most importantly, my lords, then the order under review must have also said why was the High Court wrong in holding what it did? After all, High Court has given detailed findings, including cross-examination, wherein they admit the entire consideration has been paid during, or rather 90% of the consideration has been paid.
Positive.
Balance deposited in court in the suit. That order directing deposit of balance not challenged. So for a long time now, before the Supreme Court decides this matter, in the order under review, the full consideration was deposited there. 90% during 3 months, 10% later, when the suit was filed. Now please see the relevant paragraphs that I need to show to your lordships.
Of the Supreme Court order.
Of the Supreme Court order, of the order under review. My lords, has para 5 on page 3.
Yes.
The agreement dated 19/3/94 and the registered GPA in favor of respondent number 1, purchaser, that is us, Siddha Shetty Infra Projects, could not materialize. Now this is not with us. That's the starting point.
Yes.
Now kindly come to para 32. My lords, have para 32 on page 22.
Yes.
Coming to the aforesaid indicators, the language of the agreements make it clear that severe consequences of forfeiture would ensue if the payment is not made within 3 months of the date of the agreements. It may be noted that as per clause 21, the parties had entered into an earlier agreement to sell dated 19/3/94, which did not materialize, and accordingly the agreement price therein was no longer applicable. My lords, I halt here for a minute and then I'll proceed. 21, I have told your lordships what it dealt with. That if 1 to 4 will have no claim to the consideration being paid, I'll read it out again, the clause. And now, it is in this context that the fresh agreements were entered into between the parties so as to provide a last opportunity for them to successfully enter into a sale purchase agreement. The aforesaid intention of the parties is also made clear through clause 23 of the agreement to sell, which reads as under 23, the parties of the second part herein undertake on any pretext they will not make any claim for enhancing the agreed sale consideration. Now, my lords, firstly, 21 doesn't talk about any last opportunity. I am not a signatory to the 94 agreement. And 23 also, by no stretch of imagination, is a clause which deals with time being the essence of the contract. Because that's all these clauses are being relied on, is to deduce whether time is the essence of the contract in the matter concerned or not. Now please see 33. The aforesaid clauses clearly frees any enhancement of agreed sale consideration which cannot be independent of a fixed time period. A contrary interpretation would render the contract commercially unreasonable and unworkable. The moratorium on enhancement of rates prescribed under 23 should be interpreted to be predicated on fixed time and be executable within a reasonable time. The same should not be utilized to render the commercial wisdom between the parties ocious, which is inherent in drafting such clauses. Now kindly have the next page, para 34. From the above analysis, it is clear that the contract was strictly conditioned on a time frame. At this stage, it may be relevant to quote section 55 of the Contract Act, which reads as under 55, effect of failure to perform at fixed time in contract in which time is essential. When a party to a contract promises to do a certain thing at or before a specified time, or certain things at or before specified times, and fails to do any such thing at or before the specified time, the contract or so much of it as has not been performed becomes voidable at the option of the promisee if the intention of the parties was at the time should be the essence of the contract. Now, my lords, I halt here. Did they take any step? Was there any letter rescinding the contract sent? Was the money forfeited? Was the advance returned? Nothing. I was the one who sent the legal notice ultimately in 2000. Nothing done. So how does 55 become applicable? 55 has no application in the facts of the case. Now kindly see 35.
Only so much which is not
Yes,
performed.
and that also is only so much as is not performed. If at all it were applicable. According to us, 55 is not applicable at all. Now please have 35. In view of the aforesaid provisions, the vendors were entitled to rescind the contract.
The essence of the contract in 1994 agreement?
In the 94 agreement, do we have a?
Any time period was fixed? in
Well,
the-
I'll just find out.
Check it out.
Yes, please check. Please check under the 94 agreement. Is there a clause
Have agreement.
on time being the essence? Yes. My lords, may I read on?
Yes.
In view of the aforesaid provisions, the vendors were entitled to rescind the contract. As there was a breach of condition, time was the essence. Coming back to the point of limitation, it is clear that Article 54 of the Limitation Act mandates that in this case at hand, the date fixed for consideration was 3 months from the date of the agreement, dated so and so. In any case, the time period for filing the suit had commenced on 26/27/697 and would have expired after 3 years in the end of June 2000. The purchaser has contended that legal notice issued by them on 31st/3/2000 would be sufficient to get past the bar of limitation as the purchaser has paid the advance amount to a large extent. Although this argument seems to be very attractive at first blush, the same cannot be sustained in the eye of law for the reason that when a condition of a contract is breached and the consequences ensue for that breach, a party cannot claim equity to escape such consequences. In this context, we may note that Article 54 of the Limitation Act provides for 2 consequences based on the presence of fixed time period of performance. It is only in a case where the time period for performance is not fixed that the purchaser can take recourse to the notices issued and vendors reply thereto. In the case at hand, aforesaid circumstances do not come into play as a fixed time period was clearly mandated by Clause 3, read with Clause 23 of Agreement to Sell as explained above. Now, my lords, kindly have para 38 on the next page. 38 starts there. In the light of the above, we note that the suit filed by the purchaser was clearly barred by limitation in view of the first part of Article 54 of the Act, and no amount of payment of advance could have remedied such a breach of condition. Now kindly come to para 60. On page 39. My lords, have para 60. The notice dated 8/2/2000 issued on behalf of the purchaser implicitly acknowledges the fact that time was considered as the essence, even by the purchaser themselves, and due to breach of the same, they sought novation of the agreement to sell in the following manner. However, the due efforts by my clients proved little light hope when you have strongly urged my client to take up with the balance sale consideration in view of the fact that other interested parties are not available at that moment, and you ask my clients to renew their efforts by end of January 2000, and thereafter you have promised to complete the transaction by executing the sale deed in favor of my client. Aforesaid notice at best reflects an intention by the vendor to renegotiate the terms, which was not accepted in toto by the vendor. Now, my lords, kindly have, where is time is the essence, the legal notice? Yes. Now, this is how the legal notice is dealt with. Now, kindly see the paragraphs which they rely on to say that the judgment sufficiently deals with all the issues. Kindly have first paragraph 31. I have already read out to your lordships. No, 31 I have. Please have 31, my lords. These are the paras they rely on to say that this requires no review, and even the errors which are pointed out will have no bearing because there are other paras that sufficiently deal with the reasoning. This is their argument. My lords, has para 31 on page 21. At the outset, this court has perused clause 3 of the agreement, which is in two parts. The first part provides for purchaser's obligations, while the second part details the obligations of the vendors to provide the requisite certificates. Although both the obligations are required to be completed within the stipulated period of 3 months, there is a substantive difference between these two sets of obligations. The obligation upon the vendors concerned was production of certain certificates, such as income tax exemption certificate and agricultural certificate. No consequence was spelled out for non-performance of such obligations. My lords, I halt here. Firstly, nothing turns on it, but there is a consequence. The contract stands cancelled, so it's factually incorrect. I'll just show the clause.
So therefore, Mr. Kaul,
Yes.
in this judgment, the review which you are seeking, where is the reference of 1997 agreement?
Please, my lords.
Where is the
Of whether cognizance of 1997, the fresh agreement, has been taken in this judgment or not?
Only to the limited extent that it's a last opportunity given in clause 21 and 23. That's all. That's the way it deals with it. It says 94 was the agreement. You didn't perform. Then 97, last opportunity given. 97 by virtue of a last opportunity. Look at the clauses 3, 21, 23 of the 97 clause, which clearly set out the consequences in one case and not in the other case, and says 21 clause puts the last opportunity, and 23 is the commercial wisdom. That's all that it says. Now, please.
Can we see the agreement?
Yes, my lords. Today, could I just complete the paras they are relying on, and then I'll straight away come to the clauses. So, where was I? Yes, my lords. The obligations upon the vendors concerned was production of so and so. No consequences were spelled out for non-performance of such obligations. Factually wrong. Even for not giving of documents, I had the right to cancel. Whereas the obligation on the purchaser was to make the complete payment of the sale consideration within 3 months. The clause further mandates forfeiture of advance amount if the payment of obligation is not made within the time period stipulated therein. In this context, this court in Chandrani versus so-and-so held from an analysis of the above case law, it is clear that in the case of sale of a immovable property, there is no presumption as to time being the essence of contract. The court may infer that it is to be performed in a reasonable time if the conditions are from the express terms of the contract, from the nature of the property, and from the surrounding circumstances, for example, the object of making of the contract. Now, my lords, kindly come to paragraph 58. The other paragraphs 32, 33 I have already read out. Please have para 58, which they rely on. Last opportunity. Page 38, my lords have. From the aforesaid, it is clear that the purchaser ought to have been vigilant in the case at hand to enforce his right and could not have been lackadaisical in his approach. From the facts, it is clear that the purchaser had entered into an agreement way back on 27th of March 97, which had a clause mandating completion of the contract by payment of the remaining consideration within 3 months. The aforesaid clause was drafted as alluded to earlier for providing one last opportunity. Again, the same error. As if there's a 94 agreement and then there's a 97 agreement, which is the last opportunity for the purchaser to make good their lapse, which had happened on the earlier occasion, which is the 94 occasion. There is no 94 earlier occasion. In this context, the time of performance of the contract, including How will you be reviewed? Just no, I'm saying gather your thoughts. Now, my lords, kindly have, so the substituted and that. Revenue objections and pretenses. My lords, could your lords now kindly have the clauses?
Just the relevant clauses of the.
Yes, just the relevant clauses. Just the relevant clauses. Kindly have first clause 3 on page 11115 of the original SLP, my lords. Annexure P1 starts at 109.
Next year.
P1 109, and where is clause 3? And clause 3 on page 115. Lords may take it that this agreement also refers to the earlier transaction between them and respondent 124. That is also referred to.
P1.
Yes. My lords has that?
Yes.
Clause 3. The purchaser shall pay a sum of so and so towards balance sale consideration within 3 months from this date to the parties of the second part herein. And if the purchaser does not honor to pay the balance sale consideration of 27,07,500 within a period of 3 months from the date of this date, the advance amount will be forfeited. And this agreement of sale will be cancelled if the vendors fail to furnish non-encumbrance certificate, income tax exemption certificate, agricultural certificate to the purchaser within 3 months. So the consequence of your not performing was also there, the factually wrong. Secondly, what could be forfeited was the advance amount. The High Court says, and I'll show the other clauses, that taking the whole thing into consideration, clearly time was not the essence in this matter. Please now have the next clause for your lordship's kind consideration, clause 6. On the same page. My lords has that? Clause 6.
Yes.
The parties of the first part and the parties of the second part herein undertake that they will execute a registered sale deed or deeds or any other nature of documents as desired by the purchaser in favor of the purchaser or its nominee or nominees after receiving the balance sale consideration. No date fixed again. That it has to be by this is the sale deed. Now please have clause 13. Clause 13, my lords, 19 and 25 give valuable rights to the purchaser. Clause 13, I'm not troubling your lordships. Clause 13, 19 and 25 and 27. Relating to raising of structures, creating of mortgage, etc. 13, 19, 25 and 27, but please have 21 on which so much emphasis has been laid on page 118, which is treated as the clause with last opportunity read with clause 23. Those are the two clauses which are read to say that this was the last opportunity. My lords have clause 21 on page 118. My lords.
Yes, got it.
The parties of the first part are not at all concerned to the sale consideration agreed by the parties of the second part. Here the parties of the first part are respondent 1 to 4. Respondent 1 to 4 and the original owners who sold it to 5 to 10. So the parties of the first part are not at all concerned to the sale consideration agreed by parties of the second part, who are 5 to 10. Herein, with the purchaser, as already they have received the agreed sale consideration from the parties of the second part herein, as per agreement dated 19th March 1990.
For claim in respect to the consideration payable under your agreement to your vendors. So R5 to.
Yes. And then 23, the parties of the second part herein undertake on any pretext they will not make any claim for enhancing the agreed sale consideration. Now, my lords, I put a question to myself. How do clause 21 and 23 show that time is the essence? That this was the last opportunity given, and the fundamental error starts because 94 agreement is treated as the original agreement. Then by some reasoning, which is not borne out by the records at all, a reasoning is arrived at.
One question. Para 3 of this agreement, 97 agreement, it is said that the balance amount of 27,07,500 shall be paid within a period of 3 months.
Right.
That means that the total sale consideration was fixed at rupees 38 lakhs and few thousands, right?
Yes.
What is the date of this agreement? The date of this agreement is
26th March.
26th of March 1997.
Yes.
And you said, Mr. Kaul, that you paid 90% of.
Yes. Yes. I just.
So on the date when this agreement was executed, you said 27 is the balance. When did you completed 90% of the payment towards sale?
Before 3 months.
You completed.
Yes.
So you were supposed to pay the balance 10% and get the sale deed executed.
Yes. So, my lords, please
So
see.
why this 10% was not paid?
Because the latter half of those documents which had to be given within 3 months were not being given by them.
For that, you must have issued a notice to them.
No, no,
You didn't issue any notice.
no, is only the legal notice. That's the legal notice is the first notice of 2000. I can't improve upon what is not there, my lord. What is there is there. We did not, it was all oral.
So
We asked
therefore-
him, yes.
If we calculate 3 months from the date of the agreement, it expired on 26th of June 1997,
Yes,
right?
yes,
And you issued notice on 8 February 2000,
yes,
correct?
yes. And my lords, wants the dates, I can give the dates also when the advance was paid, and then 90% was paid within 3 months, and 10% was deposited in the suit in court.
Yes.
When the suit for specific performance was filed. The reason this error has occurred, my lords, is because 94 becomes the starting point. Also for completeness, let me give you lords one fact which will not have an immediate bearing, but just as we were pursuing our rights. Now, my lords, even after entering into the agreement to sell, as per clause 27, I had the right to get the revenue records mutated. There's a clause 27. So accordingly, the revenue records, an entry was made. On their request, it was deleted. I pursued it. It was restored. And they filed an appeal against that. So initially the deputy collector deleted the name, our name. White proceedings dated 15/2/2007. Aggrieved by the same, an appeal was preferred by us before the RDO. What is the full form of RDO?
Revenue Divisional Officer.
Revenue Divisional Officer. And the same was allowed by proceedings dated 14/9/2007. Against the same, revision was preferred by the respondents, which was also dismissed. And I'm instructed to say that there is no further proceeding thereafter.
I've argued it before the High Court.
Yes, and this was argued by us before the High Court. Now, my lords, in this background, let me also show to your lordships the crucial findings of the High Court. Because ultimately, when the order under review is dealing with an impugned order, it surely has to deal with how has the High Court gone wrong.
Let's see the High Court.
Page 20.
B is the correct translation from the
Yes.
Telugu. The other must have been in Telugu or it's in English.
It's in English, the agreement,
English.
or in Telugu?
It's in English.
It's English already.
English.
No, then there's no difference.
My lords, may I now
Sometimes, translations
That's
from the local language can
kindly now have para 19, my lords. I'll need to read 4 or 5 relevant pages
of the High Court
High
judgment.
Court order, my lords. Page 17 of the original SLP, my lords.
1-7. Yes.
Now, in the present case, we have to examine the suit agreements of sale, so and so, whether any date is fixed for performance of the agreement. Clause 3 of the suit agreement are extracted for ready reference as under. The purchaser shall pay 27,07,500 so and so towards balance sale consideration within 3 months from the date of from this date to the parties of the second part herein, and if the purchaser does not honor to pay the balance sale consideration of 27,750 within a period of 3 months from the date of this date, the advance amount will be forfeited, and this agreement of sale will be cancelled if the vendors fail to furnish the non-encumbrance certificate, income tax certificate, agricultural certificate to the purchaser within 3 months. It is to be seen that clause 3 of the suit agreement, 2 limbs. The first limb of clause 3 speaks about plaintiff's obligation to pay the balance sale consideration within a period of 3 months of the agreement, and consequences of failure to pay the sale consideration within the time is that the advance amount paid by the plaintiffs will be forfeited. Admittedly, no calendar date is fixed for its performance, but the payment of total sale consideration to be made within 3 months from the date of agreements. Obviously, the performance of the suit agreement can be done only after obtaining necessary certificates, permissions by the defendants 6 and 8. Thus, it is to be presumed that unless and until the defendants produce the certificates, permissions from the competent authorities, the registration of properties could not be completed. Though it is vehemently contended by the learned counsel for defendant 6 to 8 that the plaintiff had not paid the total sale consideration within the stipulated period, but the defendants have not exercised the option of forfeiting the advance amount paid as per clause 3 of the suit agreement. The second limb of the same clause speaks about the defendant's obligation to obtain and produce the required permission certificates from the concerned authorities for completing the registration process in favor of the plaintiff and consequences of failure to produce the required permission certificates contemplates that the agreement will be cancelled. But neither the plaintiff nor the defendants have exercised the option of cancelling the suit agreements. The trial court has not understood the distinction between time fixed for payment of sale consideration and time for performance of the contract, and on wrong premise came to the conclusion that the time fixed for payment of balance sale consideration is the time for performance of the agreement, and applied the first limit of Article 54 of the Limitation Act, which is erroneous. The performance of the contract is dependent upon the factum of furnishing documents under A4 and A5 by defendants 6 and 8, and that is the reason, as rightly contended by learned senior counsel appearing for the plaintiff, that the date for specific performance of the agreement is not fixed. Then the distinction made by the learned senior counsel that there is a difference between the date of specific performance of the contract and the date of payment of the amount is also not noticed by the trial court, in coming to the conclusion that first part of Article 54 of the Limitation Act applies. As such, the basic assumption of the trial court about application of Part 1 of 54 is erroneous. Then kindly have give me a minute, my lord. Just give me a minute. Page 27 also, this has to be read.
There is a reasoned application of mind by the High Court.
On,
There's no del-
on readiness, willingness, on total consideration paid, on time not being the essence of the contract, interpreting all clauses of it, and coming to the conclusion. And what is the basis of the order under
Please give us, so this is the High Court's finding on clause 3.
Yes.
Then on readiness and willingness, which are the paragraphs, we need to read them out. But
Para
tell us.
35,
Readiness, right?
para 35 to 40 on readiness and willingness.
What is the PDF page, 35 to 40 page?
Because we have a different PDF. Our PDF number is 70, but I don't know whether that
Anyway, we check. 48.
running page 28, 35 to 40.
All right, then.
Then on payment consideration has been admitted is para. No, that's page.
Payment is what para?
Para 38 and 40 again is that the consideration has been paid.
All right. Anything else?
38 and 40. Then, and that is where they also record that their witness admits payment having been made.
All right.
Then, my lords, also mutation entries are covered in para 25 to 26,
Page, para 20, page 24.
and the final finding is on page para
24. 28.
Para?
28.
Which starts
So-
at 23 and ends at 20.
So what the High Court does it says that we will only give you land proportionate to the 90% that you had deposited on time, and the 10% needs to be returned, and you will not be entitled to that 10% proportionate land. And they were directed to pay that amount, which I'm instructed to say even that was not paid till today.
And they denied receipt of 34 lakhs also.
Initially, they attempted to.
No, come to para 36 of the High Court.
Yes,
judgment.
yes,
The witness,
yes, they did.
the witness
Yes.
admitted that is.
And then ultimately that stood proved. So our case was, we pay you 90% during, why would I not pay 10%?
5,39,000 was the balance amount.
Yes.
5,39,000.
And one was a check which got dishonored. We immediately replaced it by a demand draft, and the court records that the next day.
But the direction of the High Court that you should be given only 90% of the proportion part, that was accepted by you.
No, that is what we challenged in
Yeah.
the SLP, and
Yeah.
that's the second review, which was filed.
Oh, there was a cross SLB by you.
Yes. And we said if we have performed the full contract, then we should be given the land. Now the order under review says you were not ready and willing also. Look, your DD bounced. The next day it was replaced by another DD. So that's the kind of reasoning. But the fundamental error is 94,
That you made.
97,
We'll
last
follow up on the other
opportunity and
side.
clauses which are wholly inappropriate. And
We'll call upon.
only on, yes.
So far as that sale of the land is concerned to third parties, which is being presented before your lordships as a ground, as a preliminary ground, what had happened was they filed a writ petition before the High Court. That writ petition, and that is dealt with in the judgment of the High Court.
Why did they file a writ petition before the High Court?
134 of 2020. They say we granted permission to sell the land. The registering authority is not registering our document. Please issue a direction to the registry that your lordship will be pleased to find at page 71, paragraph 19.
Their registration in favor of that third party.
They didn't name who the third party was.
Anyway, then
And it is not being done, therefore issue a writ. The High Court says I have granted specific performance. Where is the question of allowing this writ? That writ.
so High Court was dismissed. When was it dismissed?
It's same by the impugned judge, common judgment which was impugned by them, but they only challenge that portion of the judgment which was in first appeal, not in the writ petition. Therefore, all of the purchasers cannot be said to be bona fide, is my respectful submission. That's at page 71.
So no challenge to that, the writ petition
Yes,
order.
because their SLP says, my lord, I read the prayer. The prayer is at page number 99.
Were the purchasers parties to the petition in the High Court?
No, they didn't disclose, my lord.
Oh, I see. They didn't say the names of the
Their
purchasers.
prayer is grant special leave to appeal against the impugned final judgment and order dated 23/4/2021 passed by the High Court for the state of Telangana at Hyderabad in appeal suit number 998 of 2010. No challenge to that.
It's a suit for specific performance.
Yes.
We got your point. All right, let's hear the other side. Yes, Mr. Dwivedi.
Well, to begin with the last point which my learned has taken up, the sale deed has been executed after the judgment of this honorable court. So the fact that a petition was filed in the High Court and was dismissed has no relevance not to the objection which I have taken. Because after the judgment of this honorable court, my lord, I was entitled to proceed to register the sale deed.
Yes.
So therefore, this reference to the High Court dismissing, my lord, is bereft of any substance. The second thing, Lord, which your lordships asked my learned friend, Lord, to confirm the date of serving notice, which they have not. The notice, Lord, the process fee was deposited by them on 5/10/1924 or 2024. After my Lord Justice Mishra had issued notice in September. And it was served on by email on 9/10/24. Which is 2 years after the registration of the sale deed. It was delayed, my lord. I have already submitted to your lordship, my lord, and I submit it squarely covered by lordship's judgment, my lord. We can't, a winning party is not required to wait for 2 years, my lord, for notice to be served and then, my lord, to proceed. If the Limitation Act prescribes 30 days, is in possession and utilizing the property ever since the sale deed was registered, and in the absence of the third party, my lord, if the order is recalled, then his vested right is impacted. Now, my learned friends say, my lord, doctrine of lease pendants will apply. The submission is, my lord, the lease pendants doesn't apply because some petition has been filed in the registry without getting it numbered. That is the point when even the registry has not taken cognizance of the petition, your petition is lying defective. You have chosen to keep it defective. Was registered on 13th of December 22. And the sale is before that. The winning party was entitled to execute the sale deed. The purchaser was entitled to pay off the money and buy the land. And there was no injunction of any court. No legal doctrine which prevented the parties from so acting.
Yes.
So therefore, this is the ground on which alone, your lordships, in view of Vedanta's judgment and otherwise also, there are serious latches, my lord, in this case, in the way in which the review petition was filed, processed, and got adjourned by moving a letter. So this is a very serious matter, my lords, and therefore petition should be dismissed on that ground alone. Now, so far as the merits are concerned, my lords, I am confining myself to the review application. And if I may just state for my own convenience, my lord, that in review, my lord, this court will not sit in appeal, nor, my lord, reappraising the whole evidence, because it's possible that your lordship may take a view that if we were deciding the matter originally, we may have taken a different view of the
Right.
matter.
So we have to only see if there's an error apparent on the
Is it
face of it.
error apparent on the face of record of such an egregious nature that in review petition, the highest court should intervene, my lords. And to point out some error here or there, my lord, equally, your lordships have said that there may be some errors, some discrepancies about noting the facts or bringing out their interconnection. That alone will not justify, my lords. It's an overall sense, which, because it's a specific performance matter, my lords, which is in a discretionary domain. Now, in this case, is not one where the agreement of 97 has not been noticed at all. Clause 3, 23 have been noticed. 3, 21, 23 have been noticed. Some of them extracted. And paragraph 58, which my learned friend read out, clearly shows that the court is cognizant of the 97 agreement. Now, what are the three features, my lord? Yes, I will confess, my lord, that this reference to 94 as surviving or having some bearing, etc., that part, my lord, is erroneous. But that, in my humble submission, my lord, looking at the whole judgment, the judgment proceeds on three things. One is, it's the court's understanding of clause 3. And read along with that, the court takes notice of clause 23.
That's one.
Yes, if your lordship adverts, since your
No,
lordship,
I remember that.
lordship saw the agreement.
Can you formulate the second point? First was judgment proceeds on three things. One, court's understanding of clause 3 plus clause 23.
Yes,
Then the second,
clause 3, 21 and 23.
21 and 20. Right.
And please bear in mind, my lord, that the theory that time in case of immovable property, time is not of an essence. One is not an absolute principle.
It can be overrated
And
if
has
parties
much-
make it, if parties make time.
Depends on the contracts,
Yes.
the understanding of the specific terms. Not only that, the times have changed from those not initial in the 19th century when the property escalation of prices moved very slowly. Now, that was a time, my lord, when the High Court judge's salary was 3,500 rupees. And in Supreme Court also it was 4,000. So slow escalation period. We have moved on to a fast escalation time period or other era. And even in this era, there are certain zones,
Best paras, these two, no?
metropolitan zones, where a lot it's very, very swift. Clause 3 and 23 are a consequence of recognition of that fast moving, fast escalating situation. Why does it say, my lord, 3 months? And so first is the short period prescribed, 3 months. Second, and this impugned judgment which is sought to be reviewed notes repeatedly. The second is that it is clubbed with forfeiture, will be forfeited.
So your argument, Mr. Dwivedi, is, if we have understood it correctly, so far as looking into 1994 agreement is concerned, by this court, it could be said to be an error.
Yes.
But ignore 94, look into 97, look into paras 3, 21 and 23, but for the second limb, perhaps they would have no case.
Yes.
High Court says, yes, within 3 months you were supposed to make the payment towards the balance sale consideration, but the second limb says you have to produce these documents to enable for to get the execution of the sale.
Yes. Appreciate. Lord, kindly, if you, I'm sorry if I've interrupted.
Correct. Huh?
The clause 3 has two distinct parts. The production of document is just not linked. There is nothing in clause 3 to show that my production of documents, obtaining of documents, etc. is dependent upon, and you can withhold any portion of the amount on account of.
Your contentious clause 3, there are two independent obligations.
That's why I was
You
requesting.
got your point that you have to pay us completely within 3 months.
That's right.
My obligation, if I don't perform, the agreement will be cancelled. That's your argument.
You can cancel it. That's your discretion to cancel.
So your argument is the day 3 months time period expired, the agreement stood forfeited.
Forfeited.
And if that be so, from that date, that is June 1997, within 3 years, the suit should have been
That's-
filed
And that's what the view
by
taken
virtue
by,
of the first part of Article 50.
and that's the view taken by this.
That is your argument.
That's my humble submission. And I'm adding, my lords,
And actually, therefore, you are sustaining the judgment aliende. You are sustaining.
of that 94. I'm saying exclude it, excise it from the judgment, and let's see whether it is sustainable on its own strength based on it. Now let's look at it. 23 is the most crucial, my lords. 23. That my learned friend did not read out to your lordships. Just really come to the agenda.
You read it out. We read it.
23 says that
Let's see it
it
again.
deprives me of any staking of any claim for revising the price. So therefore 3 and 23 go together, sail together, intricately interlinked. If I just read from the 3 lines only, the parties of the second part herein undertake. So I have undertaken on any pretext, they will not make any claim for enhancing the agreed sale consideration. So you can't go on speculating. It's not a question of 5 lakhs or 7 lakhs or 10 lakhs.
But if the payment within 3 months was mandatory, as you now assert, what was the reason to put clause 23? Clause 23, because if payment is to be made within, say, 3 months.
So, Milord, that shows that it is expected you will pay in 3 months entire money, because otherwise, I can raise if 3 months go, then I can ask you to raise the price. That's why, Milord, in their letter, the Supreme Court notes that there is some indication that you wanted renegotiation.
You got the point.
So therefore, I submit, Milord, that, and apart from this, if your Lordship comes to the judgment at the last paragraph 76 to 79, connected with this, that assuming it's not of essence, does it mean that you can just sleep over it, Milord, for 2 years? You issue a notice after 2 years. I can understand instead of 3 months, you are coming after 4 months or 5 months or 6 months.
So really one question, why did you not forfeit? You never forfeited, right?
Yeah, according to us, Milord, the forfeiture is automatic. That's why 23 freezes my rights. Otherwise, that 23 has no meaning. It means that you will wake up and after 5 years and then you will come with 5 lakhs and ask me, kindly see the injustice and
Actually, this clause 3 in the agreement is not happily worded.
not happily.
It has created a lot of complications.
Yes. So, Milord, kindly see the iniquity inbuilt. If our view is not accepted, then that means you can wait for 5 years. See, the price will be 40 lakhs and then you find some buyer today and sell it for 20 crores. That's the idea of freezing. It's a fast escalation zone, so 3 months. Until then, I have no right to review.
Okay.
Now we are in 2024, Milord, and 97, and the prices have gone up beyond imagination. And Para 31 clearly interprets clause 3. The two parts are distinct. So para 35 and 58, Milord, they discuss. Then 79, Milord, the last submission is that in para 79, the court records that it will be wholly, we are of the firm opinion that the contract was breached due to the conduct of the plaintiff purchaser who were not willing to perform their contract after entering into a time-sensitive agreement. In any case, it is an admitted fact.
Where do we get that, Mr. Dwivedi?
Para 79,
At internal page?
page 50.
Page 50?
Yes. Of the review petition, Milord.
No, okay. 79. 79 begins with,
are of the firm.
admittedly?
No, we are of the firm opinion.
Oh, sorry. Yes. I was looking at the hyper judgment. Sorry. We are of the firm opinion.
Yes. that the contract was breached due to the conduct of the plaintiff purchaser who were not willing to perform the contract after entering into a time-sensitive agreement. In any case, it is an admitted fact the plaintiff had paid only part consideration. Though there is a forfeiture clause in the agreement, this court, with a view of rendering complete justice between the parties, deems it appropriate to direct. So the court is now exercising a discretion. And in review, my lord, specific performance is a discretionary domain. And there is no review of the discretion, my lord. Supposing after noting all the facts, the court says that we don't feel that in view of their conduct, and there is no perversity involved. They balance the entirety of thing and they take a particular view. I submit, my lords, in. I recall just one judgment, my lord, of Jammu Kashmir, my lords. It's a service matter. And law settled was that the eligibility should be seen on the date of advertisement.
Yes.
Now, in that case, my lord, the engineers, my lord, they had appeared in the examination, but the result came later. They were accommodated and appointed. They worked for 7-8 years. When the matter came to this court, before 3 honorable judges, then 2 learned judges took the view that they should continue and their qualification subsequently is fine, no illegality. Justice Sahai took the view that no, this is illegal, but exercising 142, etc., they've been working for a very long time and therefore they should not be disturbed. So ultimately, all 3 judges, there was a review petition, and Justice Jeevan Reddy was presiding. So their lordships came in and they said, Mr. Jain, R.K. Jain, the late Mr. R.K. Jain, he said, please sit down. We are with you. Last date will be the date of advertisement. Let's hear the other side. So when I was called upon, I said, yes, this is wrong. It should be the last date of advertisement. But I said that this is a discretion domain where all 3 judges have united and said they should not be disturbed. So that part should not be reviewed. That's a judgment which is quoted.
That's okay, sir.
Yes.
Thank you, Mr. Jay. Mr. Rodgi, anything you want to add?
Yes, my lord, yes, only 5 minutes, my lord, I have heard everything. I will make only 1 line submissions, my lord. 1. My lord, the review petitioners have forfeited their right to be heard by this court in view of their machinations in filing, processing, and having the matter listed. At this stage now, my lord, more than 2 years after the judgment. That's number 1. Number 2, your lordship's view is taken on these issues. Mayawati's case, my lord, I am not citing. Number 2, my lord, the most important thing in review is not substitution of the view. Whether your lordships take the view on clause 3/23 of the 97 agreement, contrary to the view taken by the judgment under review, can never be a ground for review. Your lordship may note, my lord, it is well settled. This is, my lord, that Mayawati's case, 2013, volume 8 SCC, page 320, and the principles are summarized, my lord, at page 320 and 333, at 333, paras 20, para 20. So no substitution of the view, because the lordships are not sitting in appeal. The second important feature of a review is, my lord, not a mistake here and there, but something which affects the soundness of the judgment. That is the words put by your lordships. And that also your lordship will get, my lord, in the same judgment which I have cited, and in the same para of the principles. That soundness of the view. Therefore, consideration, my lord, of the 97 agreement in totality is, my lord, soundness of the view, because in our submission, clause 3 gets its teeth and bite only from 23. It is like a sequitur. 3 months and you, Mr. Seller, will not increase the price. That is the teeth and the bite given to 3. And next, my lord, your lordships asked a question about the documents which are in the other part of clause 3 which I heard. Para 67 of the judgment under review, if your lordship will see, clearly records a finding that the seller's evidence shows that the buyer had seen all the documents in advance. And as such, there was no reason, Miller, to doubt the issue of documents, and that was a non-issue. That is in para 67. So, my lord, by removing now 94, it is clear, is only a historical background of recital as to how transfer of title took place. It has no relevance, my lord, between me and Mr. Kaul. It is a historical recital, A sold to B, B sold to C, C sold to C. There the Supreme Court made a mistake, as if, my lord, that contract had anything to do with the contract between Mr. Kaul's client and me. But that does not affect the soundness, my lord, of the discussion and interpretation of the 1997 document. And, my lord, paras 31, 32, 33, etc. Sorry.
What should mistake in refer? Then what is the next point?
Yes. So, my lord, I had indicated to your lordships last that without 94, which was a historical recital, the judgment is sound on the 97 agreement. In coming to the conclusion, my lord, that time was of essence and these people did not pay. Therefore, my lord, by conduct and by efflux of time after 3 months, the bargain came to an end. This is a matter of construction of the document and the evidence on record. Then I mentioned to your lordship para 67, where the judgment records that all the documents were seen and examined by the plaintiff and was satisfied, and that part of clause 3 is a non-issue. Now, my lord, something very important. If, my lord, time was of essence and 3 months operated on its own, then the cause of action, my lord, was in 97. Therefore, limitation would end in 2000. Now, it is important to note that they, my lord, issued a legal notice on 8/2/2000.
That date we got right at the outset.
Yes. So that is, my lord, just 1 month short. If you calculate limitation, my lord, I mean, if you calculate from 97, the limitation is over. Sorry, not 1 month short. From 97, it is 2000. So they issued a legal notice, my lord, only in a manner to somehow create an extension of limitation. and you cannot extend limitation of your own volition. That is recorded by the judgment and the review at paras.
Your fundamental point is that limitations started running in June 97. Therefore,
Yes, it started running, my lord, because the time fixed for performance under Article 54 is 3 months, where the price will remain frozen. And they did not lift a little finger after 97, 98, 99, 2000, when they issued a self-serving notice which cannot extend limitation, and then, my lord, they filed a suit, my lord, in the year 2002, August 2002. Now, this part, my lord, is also, my lord, recorded by the judgment under appeal in para 35. I am not reading. This is also, my lord, considered. Now, something very important. My lord, the final deposit in court of the balance was only on 11th of July 2005, pending suit. So what you had to pay in 97, my lord, in the middle of 97, you make it up in July 2005. 11th July 2005. It is mentioned, my lord, in the petitioner's list of dates at page 6. It is from there that I have taken the date. Now, my lord, apply a reasonable view which the Supreme Court took on limitation and on conduct. Now, it is, my lord, well known that you have to be ready and willing from the date of the contract till the date of decree. And, my lord, even in execution, when you have to pay, you have to remain, my lord, ready and willing at all times. Now look at their conduct, and this is examined by the Supreme Court. My lord, your lordship could take a different view, but having taken that view on a totality of facts is certainly, my lord, not a case for review. Now, my lord, your lordship may note a very recent view of this court on the issue of limitation in a specific performance case in regard to this clause of the Limitation Act, Article of the Limitation Act. 2024 SCC Online SC 1915, my lord, by the bench of Justice Vikram Nath and Justice Varale. My lord, it's a short judgment. My lord, if your lordship will have a look, yes, kindly have a look at this, my lord. Kindly turn straight, my lord, to the second page at the foot para 9. After reproducing clause 50, my lord, article 54. First is the date fixed for performance. That's the primary thing. And if there is no date, then you go into effect. So, my lord, 54 is split legally, my lord, in two parts. And it has been held that the first part, my lord, is decipherable. The second part, my lord, will depend on evidence. In regard to the first part, my lord, in our case, it is 3 months. Now, my lord, see what was in this case. Coming to the facts. Sorry. My lord, sorry.
you will see the agreement.
Yeah. So, my lord, just para 9.
Para 9 we have seen.
Yeah, your lordship, see, that was a case of 1 month, my lord. Mine is a case of 3 months. Price to remain frozen. Limitation sought to be extended by a self-serving notice. And today, my lord, we are 2.5 years down, where the property has been sold. Is it a case, my lord, where the exercise of review should happen so as to, it's very well to say, oh, lease pendants and all that. But, my lord, can you now turn back everything when you have really lost? You have lost the plot, my lord, it's all over. And therefore, my lord, with respect My lord, the review should be dismissed.
5 minutes by the floor for the
Oh,
rejoinder.
Mr. Paul.
Can I pass on this small list, my lord? The view on limitation has always been so, my lord. So we have extracted all the judgments in this.
Mr. Paul, what is the impact of clause 23 on clause 3?
Well,
Their argument is that clause 23 necessarily makes time of the essence of the contract.
Let me just
All right, you can go into, we can
I'll start with Mr. Rodgi's submission and then come to Mr. Dwivedi's submissions. Man, with great respect, my learned friend was completely incorrect factually. He read out para 67 of the order under review to your lordships. That para 67 talks about documents being available with the respondents. That has been negative by the trial court and the high court, where their own lawyer has admitted it was an incorrect statement when confronted and the documents were not available. Please note those paragraphs.
Yes.
Para 39 and 40 on page 31 of the High Court order. Read with para 70 and 72.
Of the trial court?
No, it's High Court order, para 39 and 40.
That you got, 70 and
Then
72.
para 70 and 72 of the trial court order at page 215 and 216 of the SLP, which categorically records, I'm just reading out 2 lines and then your lordships can see it later. On the other hand, the learned senior counsel for the defense fairly admitted that the pleadings so made are incorrect because the defendants have not obtained such certificates. My learned friend, with great respect, is arguing contrary to record.
67 is also conflict.
And para 67 is another error apparent on the face of the record. That's again an error apparent on the face of the record, because you're going contrary to the categorical findings of the High Court and the trial court without showing how they are incorrect.
There is no such ground taken in review petition.
That's why I didn't interrupt my learned friend. My learned friend will show the same courtesy to me. My lords, may I with respect now say, the words used in clause 3 are and, with an and. It has a material bearing that the two are not independent limbs, go hand in hand. And as my lords put a pertinent question, which sale deed will be executed if you don't give these certificates? You're practically negating the transaction and reading clause 23 out of context. But also it's very important, let me tell your lordships, this whole argument of now, my lords, please keep in mind my lords, may I? Was 23, which date did he issue notice? Now, my lords, as far as clause 3 is concerned, it talks about forfeiture of the advance. The words are, what will be forfeited is the advance, not the entire consideration paid. My learned friend comes up with an oversimplistic answer to say, I took it as an automatic forfeiture. So you forgot about the other amount also paid to you. The words used in clause 3 are, if you are right, is forfeiture of the advance, not of the entire 90% sale consideration paid. And my learned friend's only answer is, I take it as automatic forfeiture, ignoring all provisions of the Contract Act that ordinarily when you revoke a voidable contract, it is by virtue of a notice, a communication. That's what section 66 of the Indian Contract Act says. In any voidable contract, there will be some proper communication. Not only do you pocket the advance amount, you pocket 90% of the sale consideration as well, and you don't feel any need to write to me resigning the contract. The words are categorical.
Right.
The advance was 11 lakhs.
Yes.
5 lakhs and 6.
So you forget about the 90% and no communication, no letter. That's also an automatic feature as per clause 3, as per you. You're reading into a contract which is not there. Now, my lord, is very important because this is with great respect and an argument of prejudice made that we delayed it. And I want to tell your lordships why. We never delayed this. Our review.
It's filed within 30 days.
Our review is filed within 30 days. Within 15 days, the defects are removed. We received a phone call. If your lordships were to go to the website, there are nothing to suggest that we delayed removal of defects. There we removed the defects within 15 days. And now I'll tell you lordships what happened. In September 2022,
26 September, exactly the date.
even before they sold the property, that High Court order that Mr. Rawal showed to your lordships came in, where they did not make us a party.
No,
Where
that
they-
is different. That order is along
No,
with,
and
they filed another
writ petition, another order came.
anticipatory writ petition.
So in
That-
January 23, we wanted to place these documents on record because we are doing things behind our back. We wanted, for completeness of narration, wanted to place all these High Court documents on record. Now, between January to when your lordships in August 23, my lord the Chief Justice issued notice for an open court hearing in the matter with which Justice Kohli disagreed. And then ultimately the whole issue took a year and it came up in January 2020. It came up in 2024 September when Justice Mishra's order came. Where is the fault on my part? Everyone has gotten up here and made the most irresponsible statement that we waited for a judge to retire. We removed the defects on time. We did what we could. In January, we wanted to bring documents on record. We did. After that, your lordships issued notice in August 23. After that, it took a year for this whole process of disagreement between Justice Kohli and your lordships' order for an open court hearing. And that was finally settled by the order of Justice Mishra saying it should be an open court hearing,
In between.
which was in September 2024. And in between, Justice Narasimha recused himself from the matter. Where is the delay on our part? Because I don't here control the registry that I'll get a matter listed when I want. Registry functions according to its own principles and the requisite independence that it has. The matter came up when it ought to have come up. How do I control all this? And you're attributing delays to me in this matter? Then, my lords, the next point for your lordships' kind consideration, and I'll cite two judgments. It has been said that not every error is what your lordships looks at. Your lordships have time and again said two things, and I'll just cite two judgments for your lordships' kind consideration. The first is where the court commits an error on fact and the same materially affects the judgment, review is maintainable. That is Sri Nivasaya versus Sri Balaji, 1998, Volume 8, SCC 312, Para 2, Para 7, and para 9. 8 and 9, para 2, para 7, para 8 and para 9. Then my lords, your lordships have said in two other judgments that any error apparent on the face of the record or a misconception of fact is a ground enough for review. And that judgment is, my lords, Board of Cricket Control versus Netaji Cricket Club, 2005, Volume 4, SCC 741, para 90, and this also, and S. Murali Sundaram versus Jyotibai, 2023, SCC Online, SC 185, para 15, and lastly, my lords, Karnail Singh versus State of Haryana, 2024 SCC Online, SC 961, para 20 and 20.1, summarizing the principles.
Just repeat it again.
Which one? The last one, my Karnail Singh versus State of Haryana, 2024 SCC Online, SC 961, para 20 and para 20.1. My lords, our respectful submission is that there are 4 material errors and misconceptions of fact which are germane, materially affect the outcome and go to the root of the matter. And those are treating the 94 agreement as the agreement between us and the respondents.
Just one second. Yes.
Treating the 94 agreement as an agreement between us and the respondents, then completely, which I am not a party to, then completely misinterpreting clause 21 to say that was the last opportunity and thus time was the essence. 21 has nothing to do with time. It only said that respondent 1 to 4 would have no right to the consideration. The other error was treating 97 as a last opportunity, relying on 21 as if 94 was some agreement I did not fulfill due to my faults, and thus time is the essence.
That's the second.
Yes, that's the second point. Then thirdly, in para 67, a material error by saying that they were ready and willing and the documents were available, which is in the teeth of the High Court findings, which I told you, which I pointed out to your lordships. Fourth error is reading clause 3 and 23 in a manner which is not borne out from the record. 3 specifically says you can only forfeit the advance amount. The word and is used there. The sale deed clause 6 does not have a time period for execution of the sale deed, and you pick up clause 23, which says that the sale consideration is frozen and say time is the essence, ignoring the words of 3. And 3 said, as your lordships rightly put it to them,
clause 23 and clause 3 and 23, contrary to the record, you said clause 3 provides for forfeiture
of only the advance amount.
The advance.
The words used are and. The two limbs go hand in hand. And you have no notice. My learned friend's only answer is it was automatic feature. What about the advance 90% consideration? The documents I have pointed out, they did not have. I have shown the paras, they did not have those documents at all. Then the legal notice.
Should it not be construed to be understood? Whatever you pay till the last date of expiry of 3 months will stand forfeited.
With great respect, my lord.
Because
Yes.
on the date when the agreement was executed, you had paid 11.
Yes.
You were supposed to pay 27.
Yes.
And by the time the 3 months period came to an end, you deposited more, something more, only 10% was left.
Yes.
So should this not be construed as whatever is paid till the expiry of the period of 3 months will stand
11
for.
was separate. 11 lakhs was advance amount.
Understood.
Surely, I'm just attempting to assist your lordship.
What is the idea in saying that the advance will be forfeited?
Yes, the advance is the advance amount given, not the sale consideration after that. How can advance be read to mean the sale consideration?
Be a part of the sale consideration.
Yes. Unless the clause is defined. Clause 2. Please have, this is the agreement. My lords, please have page 114. Please have page 114, clause 2. Advance in earnest.
5 lakhs plus 6 lakhs.
Advance in earnest money are defined there. My lords, how can a party say that I will read advance in earnest money which is defined in the contract as to meet the 90% of the sale consideration as well? My lords, just one more thing, my lords. Please have para 79 for a minute, my lords. That is the last issue I want to deal with, list pendants, just for a minute, my lords. Para 79
Of the Supreme Court judge.
of the order under review. Kindly have about 5 lines down, though there is a forfeiture clause. My lords, has that?
Yes.
Though there is a forfeiture clause in the agreement, this court, with a view of rendering complete justice between the parties, deems it appropriate to direct the vendor's applicants to repay the said amount with interest or so and so from the date of such payment was made by the purchaser to the vendors till the entire amount is paid back. And then see the last para, the appeal is allowed on the above terms. Even if I take their case to be correct, which I am not admitting, this amount is not paid. And the order under review,
It has been paid, deposited.
according to us, not.
It has been deposited in court.
No, you
Yes.
can deposit it, not to us. Now,
You are
according
not
to
taking
us,
the
in
deposit
any
in
case,
court.
that's a separate issue. But the fact
don't
remains
say.
in the matter is, these are my instructions, the fact of the proceeding takes place.
When is
The dates are clear. I filed my review within less than a month of the judgment being passed. It's not that I was waiting. If I was waiting for every judge to retire, I would not have filed my review within less than a month. So don't make these allegations which have no basis at all. And then after that, my lords, you after that sell the property. And then I've explained that you filed writ petitions where I'm not made a party. I tried to bring those documents on record. I removed my defects within 15 days. And since then till August 2023, the first time notice is given for open hearing, and then August 23 to September 24. The issue of open court hearing is decided. It comes up after that for an open court hearing, and your lordships then list it immediately thereafter in October and in November now for an open court hearing. So where is the delay on my part? And as far as list pendants, 52 squarely applies. The party who buys from you buys with whatever encumbrances that come with the rule of list pendants. If you succeed, he succeeds. If you don't succeed, he doesn't get a superior right. And that is why, my lords, I showed clauses of the contracts.
There is one very
Right now, both sides. you want.
one very important portion on their conduct. Their conduct is reflecting in what is told to your lordships as far as back on 16/5/2023. They say that we sold this property on 14/10/2022 after the judgment of this honorable court of which we are seeking review. On 16th May, my lord, they say the respondents in the caption review petition are trying to get the property surveyed. However, the review petitioner is objecting with the said government surveyor citing pendency of the caption review petition to stall survey as such. Respondent, who is almost 80 years old, is not able to enjoy the orders passed by this court even after 8 months from the date of the order. That transaction is a sham because they go to the High Court on 26th of September.
Is this
but,
review, my lord, is this
2022.
review?
Anyway, that's we'll consider.
My lord, may I say just two sentences?
Now it's okay. We'll hear.
Just two sentences.
Yes.
First, the word "and" in entry tax fraud 304, your lordship said when it is with power, then they are not conjunctive. And because there are two powers, 3 months I forfeit,
For 2 minutes.
3 months you cancel. They're two different.
We'll come back in 5 minutes. We're just rising for a little comfort break. We'll be back. And this argument's concluded.
And our submission is there's no cause for recall.